Hello, good afternoon and welcome to today's Knowledge Bank titled Beware of Hidden Ground Rent Clauses. This afternoon's session will be hosted by Shilpa, partner and Head of Property Litigation at Osbornes Law. Shilpa will be focusing on the ground rent scandal in this session and negligence arising from ground rent clauses. She is an experienced property litigation lawyer specialising in all aspects of property law in a residential and commercial context. Shilpa will be taking your questions at the end of the session, so please feel free to submit them through the Q&A button at the bottom of your screen, and she will try to get through as many as possible at the end. I will now hand you over to Shilpa. Good afternoon, Shilpa.
Good afternoon, Vicky. Thank you very much. Good afternoon, and thank you for inviting me to talk to you this afternoon about the ground rent scandal. The plan, as Vicky said, the plan is that I'll be talking for just over 45 minutes, and then at the end I'll address any questions which you can leave in the Q&A. Alternatively, if we run out of time, I will be putting up my email address so that you can email me personally with any questions, which I'll try my best to answer. There is also a paper that goes with this talk, which Vicky has agreed to circulate, and I will send her a link to that paper. So you should have the slides in front of you on the screen, and what we're going to cover today is what ground rent is. We'll talk a little bit about the scandal, your options if you find you have a doubling rent clause, issues that you, when considering negligence action against your solicitors, and we'll also talk briefly about the basic elements of negligence, and we'll talk about the future. So, what is ground rent? Well, where a home is sold as a leasehold, the leaseholder owns the house itself. It's the freeholder who owns the land, so a leaseholder is required to pay ground rent annually to reflect the value of occupying the land or the ground. The requirement to pay ground rent is incorporated into the terms of the lease. Now, moving on to the ground rent scandal. In 2000, around 2000, developers started building homes and letting these out on long leases whilst retaining the ownership of the freehold company. Historically, ground rents have been low. However, developers looking to retain a steady income from leaseholders have started to increase ground rents. The ground rent provisions. In some cases, developers have reviewed the ground periodically, for example, every 5, 10 or 25 years, and then allow the freeholder to increase the rent those periods. In theory, this may not sound too bad, where the term of the lease is long, but often developers were granting 919-year leases. So typically, if you start with the ground rent, of £250 per year, which doubles every 10 years, you expect to pay £16,000 per year after 60 years. This is likely to be unmanageable for a large many leaseholders, and this, together with the service charges and other charges payable, such as major works under their lease, may mean that the leaseholder can no longer afford to keep the property. Certainly, many leaseholders who have purchased these properties have now become aware of the position as a result of the large media attention. But I still get calls from clients who have suddenly become aware of the clause as a result of their freeholder exercising their right to review the ground rent and increasing it. They then call me and suddenly discover that they have this doubling rent clause. So what problems occur? The problems is that we've seen these ground rent demands can often start off at a manageable level, but will in later years become a problem for leaseholders. And this can be a problem later when a leaseholder is looking to sell their lease. As a result, leases with such clauses will often be hard to sell. Proposed purchasers will often not get a mortgage to buy the property, as mortgage companies do not like lending where properties have such clauses. Now, paragraph 5.14.9 of the UK Finance of Mortgage Lenders, which was formerly known as the Council of Mortgage Lenders, CML, the handbook provides, if you consider any increase in ground rent may materially affect the value of the property, you must report this to us. So this is advice to solicitors. Even if there is a cash buyer and a mortgage is not required by the buyer, purchasers will simply not wish to buy a property which they themselves will have problems later. When they're trying to sell. These problems clearly can have an immense impact on the value of such properties, and in many cases, the properties may become worthless.
Shilpa, I'm really sorry to interrupt you, but the slides are no longer showing.
Yeah. Oh.
You might need to reshare them because
okay, bear with me.
They're not visible anymore. That's it. Perfect.
All right. Okay.
Yeah.
All right. Sorry about that. As I say, the slides will be available. I'm sure Vicky can circulate them. We'll now turn to a case study, which I will refer to throughout the talk. The facts of the case are a client purchases and exchanges on the purchase of a property on the 3rd of June 2011 and purchases a leasehold property for £200,000. Client instructed a firm of solicitors to represent him and his lender. Whilst reporting to the client, the solicitor simply advises the client, sign this lease, but read it carefully before you do so. The lease contained the following clause, which you'll see on your screen. Clause 1, which is the ground rent clause, which provides for the payment of £350 in advance on the 30th day of March each year. Then further down in the lease, embedded later in the lease, is a rent review clause, which provides there shall be a rent review every 5 years at the first review, and at the first review date, a sum equating to 1.5 times the initial rent, and thereafter on each subsequent review date, a sum equating to double the last rent review. The client was not aware of the clause when he completed the lease, but subsequently became aware of it when the freeholder sent him a demand for the increased rent 5 years having passed. So, what are the leasehold's options? Well, if the leaseholder is in a good financial position, they could possibly consider purchasing the freehold under the Leasehold Reform Urban Development Act 1993, but in many cases, and as a result of the doubling rent clause, the price of the freehold will be inflated, making the purchase of the freehold impossible. This equally applies to lease extensions. A lease extension under the Act can result in the ground rent in the lease being reduced to a peppercorn. However, the existence of the doubling rent clause will mean that the premium for the lease extension is unmanageable for the leaseholder. Another alternative is for the leaseholder to engage with the freeholder and see if the freeholder is prepared to agree a variation of the lease. Often, however, the freeholder will want a significant sum to agree a variation, and therefore may not be a viable solution for the leaseholder either. In 2019, so turning to alternative clauses that you might agree if you were agreeing a variation, there has been reference to agreeing an RPI clause. Now, in 2019, companies such as Taylor Wimpey, Morris Homes and Bellway committed to amending the lease where the ground rent doubled more frequently than every 20 years to contracts where the ground rent rises in line with RPI inflation. A few years ago, RPI clauses were considered to be the industry standard, but these clauses bring with them their own difficulties, given that it's impossible to predict what the RPI will be in the future. So the clause does not provide any certainty to any leaseholder. So many leaseholders don't like them. In respect to the lenders, they all take different stances. The Office of National Statistics has reported that RPI has lost its status as a national statistic, as not a good measure of inflation, and they no longer encourage its use. As I say, lenders treat it very differently. For example, Yorkshire Building Society requires ground rent reviews to be a minimum of 21 years from the start of the lease, as opposed to Barclays, who will not lend on leasehold properties with onerous terms, including unreasonable escalating ground rents, and relies on an independent valuer's professional opinion as to the impact of the lease terms on the value and future saleability of a property. Another option for the leaseholder in this position is to go back to their conveyancing solicitor, who advise them in relation to the purchase of the property, and potentially pursue them for negligence for failing to advise properly when they purchase the lease. But has there been any negligence? Now, this is a question of fact and will depend on the individual facts of a case. It is most important when dealing with clients in this situation that you seek a copy of their conveyancing file. Now, I get lots of calls from potential clients who tell me, I've got everything that the solicitor sent me, so I can put the file together. We do need, solicitors do need to see the actual conveyancing file. It's important for many reasons, but because the conveyancing file will have things in it which perhaps the client doesn't have. As solicitors, we're obviously required to keep attendance notes of conversations that we have. There'll be letters to third parties, there'll be letters to the lender, and this all helps and assists us in advising whether there potentially has been any negligence. So it's important to advise a client in this situation to actually get hold of the actual conveyancing file, and there shouldn't be any reason why they're not entitled to it. If they have completed the conveyancing, paid the solicitor's bills, invoice, they are entitled to it. So turning to the actual negligence and how it can be pursued. It can be pursued under a tort or contract. A tortious duty of care arises whether or not there is a contractual relationship between the parties. Where there is a contractual relationship, which will mostly, in this case, there will be, professional may owe concurrent duties in both contract and in tort. Generally, professionals such as solicitors, as I say, are taken to have assumed responsibility towards their client, and so owe duties both in tort and contract. If there is a concurrent duty then the claimant can choose whether to bring the action under tort or contract. One of the deciding factors, which I'll discuss, is limitation, as well as the measure of damages. For instance, in tort, the damages are based on the loss that the claimant should be compensated for as a result of the tort. The claimant is entitled to be restored to the position that it would have been in had the tort not been committed. In respect of contract, the purpose of an award of damages is to compensate the injured party for the loss rather than punish the wrongdoer. The general rule is that damages should, so far as monetary award can do, place the claimant in the same position as if the contract had been performed. So moving on to limitation. It's incredibly important when a client becomes aware of this potential problem that they contact their lawyer or someone who can advise them properly in relation to a potential claim, because any claim needs to be issued within a particular time. It's commonly known that to issue a claim under tort or simple contract, you need to do this within 6 years from the date on which the cause of action accrues. The cause of action in contract accrues on the date when the breach occurs, whether or not damage is suffered at that time. Usually this will be on the date of completion, but not always. Accordingly, any action for breach of contract must be brought within 6 years of the date of completion. So if we go back to our case study, the lease completed on the 3rd of June 2011. 6 years has gone by. They should have issued by the 2nd of June 2017, and therefore they're statute barred in pursuing a claim under contract. The cause of action in tort accrues when the claimant suffers an actionable damage. The ground rent review clause does not have the immediate effect of increasing the ground rent. However, by entering the leaseholder suffers an immediate loss at completion. Accordingly, in our case study again, if proceedings are not brought within 6 years of completion, i.e. the 3rd of June 2011, then they are statute barred in bringing a claim. So what happens to our poor leaseholder in our case study? Well, there is a saving grace where a leaseholder is unaware at the time of completion that they have suffered damages, and they become aware until years later. So if at the time the leaseholder's cause of action accrues, they do not have knowledge of all material facts, then limitation may be extended to 3 years from the date the claimant knows or ought to have known each of the following: the material facts about the loss suffered, the identity of the defendant, and the cause of action. So, as you recall in my case study, I said that the leaseholder received a demand for the increased rent after it was reviewed. Let's say that was in 2020, say in June 2020. Then it would be said that the limitation of 3 years runs from June 2020 rather than the completion date, because that was the time when the leaseholder became aware of all the material facts about the loss suffered, the identity of the defendant, and the cause of action, i.e. they have a claim against their solicitor for professional negligence. Any extended limitation period under this action is subject to a long stop period of 15 years from the date of the Negligent Act. As I said, it's therefore important that if anyone is considering negligence, that they don't hang around and that they seek advice as soon as possible. Okay, so what are the requirements of negligence? For contract, we need to show that there has been a breach of the term of the contract, and there is an implied term when you're a provider of any service under Section 13 of the Supply of Goods and Services Act 1982, that service will be provided with reasonable care and skill. This means the professional undertakes to possess and to exercise reasonable skill in the art he or she professes, and the client is entitled to rely on the professional to exercise the highest degree of skill and care that a competent professional would exercise in work of that kind. The basic requirements of tort of negligence must be proved by the claimant on a balance of probabilities. Namely, they have to show there was a duty of care, the defendant owed the claimant a duty not to cause that type of harm, breach of duty, the defendant breached that duty that was owed, and causation. This has two elements, both of which must be proved. Factual causation, the claimant must prove that but for the defendant's negligence, the claimant would not have suffered loss, and legal causation or remoteness, whether the defendant's negligence was the legal cause of the loss. So looking at breach of duty, the test for breach of duty is what the reasonably competent practitioner would do, having regard to the standards normally adopted in his or her profession. So in our case study, would a reasonably competent practitioner have done more to bring the relevant review clause to the client's attention, rather than simply saying, read the lease carefully before you sign it? There is a fine line here, as it is not a solicitor's duty to advise on whether a specific transaction is prudent, for instance, as to price. But this should be distinguished from giving a warning to a client about a potential trap or problems involved with the transaction. And often this distinction is what is difficult to draw. Now, I'm going to refer to a case, it's Minking versus Landsberg in 2015, where Jackson LJ summarised the key principles that must be considered. The first principle, a solicitor's contractual duty is to carry out the task which the client has instructed and the solicitor has agreed to undertake. 2, it is implicit in the solicitor's retainer that he or she will proffer advice which is reasonably incidental to the work that he or she is carrying out. 3, in determining what advice is reasonably incidental, it is necessary to have regard to all the circumstances of the case, including the character and experience of the client. So, fourthly, the judge mentioned that you need to consider the client in this particular circumstances, which is why the facts of the case are incredibly important. So, for instance, an experienced businessman will not wish to pay for being told that which he or she already knows, whilst an impoverished client will not wish to pay for advice which he or she cannot afford. An inexperienced client will expect to be warned of risks which are or should be apparent to the solicitor, but not to the client. The solicitors and the client may, by agreement, limit these duties which would otherwise form part of the solicitor's duty, but it is, as a matter of good practice, for that to be recorded and confirmed in writing by the solicitor. If the solicitor doesn't do that, the court may not accept there was any restriction on his ability to advise or the requirement to advise, and he essentially should have advised accordingly. Now, this is taken further in a case called Credit Leonard versus Russell, Jones and Walker. And in that case, it was said a solicitor is not a general insurer against his client's legal problems. His duties are defined by the terms of a retainer. However, solicitors do have a duty to warn outside their precise instructions. So in that case, the judge referred to the case of a dentist. When you go to a dentist to have a particular tooth removed or particular treatment, if while undertaking that treatment, the dentist notices another rotten tooth, is there a duty for him to inform you? Well, you would expect so. You would expect the dentist to have noticed that other tooth and to say you're going to need further treatment. So the judge went on in that case to say, so too, if in the course of carrying out any particular instructions within the area of competence, a lawyer notices or ought to have noticed a problem or risk for the client of which it is reasonable to assume that that client may not be aware, the lawyers must warn him. So, going back to our case study, we had the client who was simply told to sign the lease, read it carefully and sign the lease. No specific mention was made of the rent review clause in the lease. And that clause is obviously a trap, a potential problem for this client, especially as the years pass. So the argument is that it being a fairly unusual and an onerous clause was enough to oblige the solicitor to draw it specifically to the client's attention and to discuss it further with them. Obviously, at that time, for instance, in the case study, if this was a new lease, then at that time, the client had the power to walk away from the transaction or potentially negotiate the removal of such clause. Now that obviously is lost by the fact that we have now completed. As I say, although whilst the solicitor is not a general insurer, they do have a duty to warn if there was a potentially onerous clause in the lease, and the client can't be expected to know about it. So, as well as the breach of duty, the other test is causation. The preliminary tests ask the question, if the loss would have happened in any event, the breach could not be said to cause the loss, i.e. the but-for test, which I mentioned. So in our scenario, in our case study, if the client would not have purchased the property had she known about the rent review clause, then causation would be established. Also looking at it another way, in our case, if there is a lender, and we've seen the restrictions that lenders have in respect of such clauses, if the lender had been informed of this clause in the lease, would the lender have lent on the property? And if it's unlikely that they would have lent on the property, then again, the client would not have purchased the lease. So those are sorts of things that they will look at when they're discussing causation. In terms of what the duties on the leaseholder are, where there is a duty to mitigate loss. So, for instance, if in our case study, the client purchased a property for £200,000 and it's now worthless, well, it does not automatically mean that the client will, if they show negligence, recover £200,000. They have to show that they mitigated their loss. The claimant cannot recover damages for any part of this loss that he could have avoided by taking reasonable steps. So in the current case, the claimant would therefore have a duty to minimise loss by communicating with its freeholder to establish whether the freeholder will agree to a variation of the lease. And if they do agree to a variation of the lease, what are their charges going to be? So earlier on, I mentioned that's one of the options for a leaseholder to take where they're faced with this type of situation. And normally, where you're dealing with a potential negligence case, it is automatically done side by side to see what potentially you could negotiate with the freeholder. For instance, if the freeholder agreed to vary the lease and remove the clause or change it and charge £50,000, then your loss would be £50,000, and that would be your claim against the insurers for the solicitors, rather than the loss of £200,000. Okay, so we going back quickly, I discussed the potential for showing that this loss was caused by the breach. I had a case where I was acting for a client who had purchased a property, and essentially he had told the solicitor that he wanted to develop the loft once he'd finished purchasing, and he had already been making inquiries of the local planning authority in respect of what potentially what he could do. It turned out that he did not own the actual loft area following completion, and it was only following completion that he found out that he would have to acquire the loft. Now, the solicitor knew that he wanted to develop the loft area, so you would have thought that potentially he would be required to, the solicitor would have looked at this and made sure that he advised the client properly as to, and warn him that actually you don't own the loft. I know you're making all these plans, but you don't own the loft. So potentially that could be a negligent act. However, it turned out that during the course of correspondence with the solicitors, the client had actually said that he did not want particularly to do the loft extension. He would go ahead and buy this anyway. So in that situation, causation would have been an incredibly difficult to show, where he has put in writing that he would have purchased the property without the loft. So that element of the case would have been difficult to prove. So looking at the future of this area. Well, many of you will know that the Leasehold Reform Bill, which had its first reading on the 12th of May 2021, has been stated by the government to prevent the practice of onerous and escalating ground rents from affecting future leaseholders. Note the emphasis on future. So the legislation is expected to apply to leases of dwellings in England and Wales. So both houses and flats will be covered by the legislation. As I note, the reference to future leaseholders, it is not intended to have retrospective effect, and existing leases will stay as they are. So leaseholders currently with such leases will not be able to seek assistance from the bill as it's currently presented. The bill is intended to restrict the payment of rents in qualifying future residential long leases, i.e. those granted after the legislation is enacted for terms certain exceeding 21 years, such that freeholders can then make no financial demand in respect of ground rent. Instead, a peppercorn rent will apply, meaning that nothing more than a peppercorn can be sought from leaseholders. It may be possible to apply the new regulations to an existing lease if it is varied. So for instance, where a leaseholder actually acquires a new area of the building, for instance, a garden or a loft, and the lease needs to be varied, and there is some kind of deed of variation or a surrender or regrant, which alters or to show alters the demise and to show the enlarged premises, lease may be classed as a new lease under the rules. Once the works are completed, and this new lease may fall under the new regulations, rendering the ground rent provisions within the old lease unenforceable. So again, there'll be a requirement that that lease be at a peppercorn rent. The new bill also introduces new rights for trading standards to levy penalties on freeholders of up to £5,000 for breaches of the law. Now, it remains to be seen what impact this reform will have, but given the government's intentions is hope that this will put an end to the leasehold scandal, although it is unlikely to help or assist those leaseholders who have already entered into such leases. So those leaseholders will obviously still be looking at potential negotiation with their freeholder, trying to extend their lease or purchase freehold, and potential negligence action against their conveyancing solicitors. I think that covers mostly, I think just under 40 minutes, what I need to say. I'm not sure if there are any questions. Let me have a look. I can't see any questions.
Hi, Shilpa. I think there's only one question at the moment. Do you want me to read it out for you?
Yes, if you could.
Okay, so the question is from Mark. It just says, Shilpa, great presentation. As an expert, who do you think is responsible for the leasehold scandal? It's quite a controversial question.
Oh, yes, very controversial. Well, I mean, as I said in my presentation, historically, this is ground rents have been quite at a low level, and if you look at some of the old leases that I come across, ground rents are very low. But this practice of increasing ground rents sort of developed in the 2000s, and it was something that was pushed by developers. So that practice has become common. So I would have thought that it's these developers, the institutional landlords, push these types of clauses, push these reviews, and it's now been it then got picked up by lots of other landlords. I mean, in the case I was involved with, it wasn't even an institutional landlord. It was an individual landlord who'd put a review clause in the lease. So it's that practice that obviously has prompted this and has resulted in this legislation, in the government having to legislate. So I think that's as far as I can go in terms of responsibility for this.
Yeah, I think that's a fair answer. There's one more question that's just come in from Prosper. Says, you mention a long stop date of 15 years, but what if the RR period is every 20 years and the tenant only becomes aware of the issue at the 20th year?
This is the difficulty that can occur. If in those cases, often the claim for negligent act is statute barred. As I say, if there is a particular case, it must be looked at very carefully, because there may be an argument that can be made. But if the rent review date is at 20 years, then that could potentially be a problem, because it will be more than 15 years from the negligent act. So there have been clients that I haven't been able to assist because it's been so far along. So it's important to get proper advice on that.
Okay, and then I think there's just one more question here from Stuart.
Yep.
Can you confirm if the new reform bill is all new leases, including informal, at zero rent, as I thought it was zero rent after the original term expires? Albeit, I don't know why a leaseholder would want that.
I don't know, sorry, you cut off there.
Albeit, I don't know why a leaseholder would want that.
No. Yeah, the bill, the way it's been presented is that any new lease, and as I said, a new lease may be a lease which has been varied and there's been a deed of surrender and regrant. And it's in relation to that new lease, and we will have to look at definition of new lease carefully, that the peppercorn rent will apply.
Okay, yeah,
Right.
good answer. Yeah, so that's all of the questions, I think, now.
Okay, that's fine. So I will circulate. I will let you have my paper so that you can circulate it.
Yeah.
And obviously, if anyone has any questions, then they can contact me by email, and I'd be happy to respond to that.
Okay. Well, thank you so much for sharing all of your knowledge with us today, Shilpa.
Thank you very much.
It's helped a lot of people. As Shilpa said, I will send out a copy of the presentation and also the recording if anyone would like to watch it back. Our next Knowledge Bank will be on the 20th of July, which will be discussing major works projects and Section 20 legislation. So if anyone is interested in joining us then please register for free on the website. Other than that, thank you very much, and that's the end of today's session.
Thank you.
Thank you, Shilpa. Bye.
Thank you. Goodbye.